Thank you so much. I am so pleased to be here and so grateful to have the invitation. And in addition, very, very grateful to everybody for taking the time to join us today. I have 90 minutes, which is an incredible gift of time to spend talking about this topic. And I hope that I can make this engaging and relevant for you in your work. So with that, I will jump right in. And as we go, I'll talk a little bit more about myself, a little bit more about the Minnesota Elder Justice Center, and we can begin to explore these themes of guardianship, conservatorship, supported decision-making, and in general, our decision-making in the law. So I mentioned a little bit, some of the themes are in the title. Other things that we'll touch on today involve discussion about self-determination and autonomy. We'll explore questions about capacity and incapacity as it relates to guardianship and conservatorship. And then we'll talk about risk, safety, oversight. And I really hope to be able to connect these themes with your work in advocacy and to show how these questions arise for us at the Elder Justice Center and to talk with you about how they arise for you. Just briefly about the organization that I work for, as Nikki introduced me, my name is Marit Peterson. I am the Associate Director at the Minnesota Elder Justice Center, and I've been there since 2015. We have the mission here on the screen, and we attempt to meet that mission in 4 primary ways here. Public awareness, we do a lot of public education and outreach in that regard. Professional education, which is what we might consider opportunities like this to speak to other professionals about issues that impact older or vulnerable adults. Public policy advocacy, which is in full swing right now as a session is underway. And direct services, we have a team providing direct service advocacy, as well as legal representation for older or vulnerable adults under certain circumstances. So we are always happy to connect with individuals that you think might need some additional support or any other kinds of systems navigation or information about the situation they might find themselves in. And like Standpoint, we're also always happy to provide technical assistance or support resource to professionals who are serving older or vulnerable adults in Minnesota. Our work is oriented around Minnesota. We serve the state of Minnesota, and we have members of our team who are across the state. So we try to make sure that we have some sense for regional issues that might be arising or needs in that regard as well. And I put on this slide, our contact information, website, phone number. I also have my contact as well towards the end of the presentation, but I put in huge letters that our services are provided pro bono. We do not charge for direct services. This is because I always forget to say that routinely, or I used to. And that's an important part of what we do and an important piece of information for you to have, as well as the folks that we would hope to serve. So that is a little bit about our organization, the Elder Justice Center. In my professional role there, I supervise our direct services as well as our training and education. I'm trained as an attorney, and so my perspective comes out of direct representation for clients in an estate planning, probate, elder law context. So when I see issues arise with decision making, often my first frame is that legal frame, and that is what we'll talk about today. I did want to make one brief reference to the way that one of the ways that these issues related to decision making intersect with our work around abuse, neglect, and financial exploitation at the Elder Justice Center. And here's one way in which that transpires. Many of our callers have concerns about financial exploitation, as well as those who are serving folks who have experienced financial exploitation or financial harm. And here in Minnesota, we have a financial exploitation statute. I'll try not to become too, well, I'm going to become a bit statute-y in this discussion, but I'll try not to belabor that. Nonetheless, we have a financial exploitation statute here in Minnesota that does call out a breach of fiduciary duty. Now, these I'm already getting dense in terms of terminology, so we are going to take a step back and we'll define some of these terms, but I'm not going to come back to the financial exploitation statute again in the presentation, so I'll just point out that a fiduciary relationship is created in a conservatorship. And so when we see harm happen in that context, one of the tools in our responsive toolbox is the Minnesota Financial Exploitation Statute that makes the breach of a fiduciary duty to a vulnerable adult a crime. So that's an interesting and a helpful opportunity for us as we look at the scheme of response to situations in which we might find a fiduciary relationship. We'll come back to that and we can explore that in greater depth. But I wanted to put the statute up here so you could see just one example of the way that decision making and in this case, financial loss can intersect because based on a decision making relationship, there arise some obligations to make decisions in particular ways. So today we're talking about guardianship, conservatorship, and supported decision-making and the way that those structures act in the law. And we'll also be talking about, I hope, your work as advocates in the way that these issues arise for you. And I'd like to address also the ways we might approach scenarios when we become aware that there is abuse, neglect, or exploitation happening within the context of the guardianship relationship. So the person subject to guardianship and the guardian, or the person subject to conservatorship and the conservator. There's another way of thinking and talking about this as well, which is related to supported decision making when we don't in fact have a court appointed guardian or conservator, but a group of supporters. And we can talk a little bit about those dynamics as well. But something that I do want to mention right off the bat regarding guardianship and conservatorship is that we see here an inherent imbalance in power. The court has given decisional power in the context of guardianship or conservatorship to one individual and has taken it from another. And so when we think about the way that power and control shows up in our work, we know that there is a guardianship or conservatorship in place. We can begin from a place of understanding that the power imbalance there is real and significant and is experienced most profoundly by the person subject to guardianship or the person subject to conservatorship. So just from that starting point, we'll begin and we'll talk about guardianship and conservatorship first, because I'd like to frame supported decision-making not necessarily as a direct alternative to guardianship or conservatorship, because I think it actually is more broadly applicable, but also I want to show how supported decision-making appears in our guardianship and conservatorship statute. So we'll take it up as it arises in that context. First, let's talk briefly about guardianship and conservatorship in general. So when we think about these concepts, and you'll see that the bottom two bullets kind of break down some terminology here. A guardian is a court-appointed role, and a conservator is a court-appointed role. And you can see here that conservators are concerned with the money and assets of a person, what we might describe as the estate of a person, what they own. And the guardians are concerned with personal life decisions and care decisions, medical treatment decisions in certain circumstances. And so you can see kind of how the roles are divided here. In Minnesota, we have both roles defined in our statute. We have a role for a guardian, and we call that person a guardian. A person who has a court-appointed guardian is referred to as a person subject to guardianship. And we'll see that often abbreviated as PSG, sometimes in court documents, sometimes in other communication. This terminology is relatively new in our Minnesota statute, and it takes the place of some other more dated and very much less person-centered terminology that we no longer use. But I'll tell you what it is so that you understand what I'm talking about. We used to use the terms ward and protected person. So when you hear the language of ward or protected person, you can translate that in your mind to person subject to guardianship or person subject to conservatorship. So we see here the court appoints a guardian or conservator, and this person is what we would refer to ultimately as a substitute or surrogate decision maker, because they are entitled to make final decisions about whatever areas are identified in the guardianship or conservatorship order. We'll talk about the various powers and duties of guardians and conservators as well. But those powers and duties are called out in a court order, the court order that appoints the guardian and or conservator. Many people have either a guardian or conservator, and many have both. So it depends on what kinds of decisions need to be made. And then guardianship and conservatorship can be both voluntary or involuntary. And you'll see here involuntary guardianship and conservatorship is the most common form of guardianship and conservatorship. That describes a situation in which the person subject to guardianship or the person subject to conservatorship ultimately objects to having a guardian or conservator. Under some circumstances, a person may recognize their need or desire to have a guardian or conservator, and those voluntary situations are relatively straightforward. We'll talk about the process of becoming a guardian or conservator as well, and so you can see how that voluntary approach differs from a situation that might be involuntary, a much more common situation. As I look at the slide, I'm reminded that I want to point out, you'll see the logo for the Minnesota Elder Justice Center in the bottom right-hand corner, but in the bottom left, you'll see another logo, which is the Center for Excellence in Supported Decision-Making at Volunteers of America. And I'm going to credit the Center for Excellence in Supported Decision-Making, as well as Anita Raymond, who is their director, with these slides, which she and I have collaborated on to create. I am tremendously grateful for the partnership of the Center for Excellence in Supported Decision-Making. And so you'll see them referenced as a resource. But if you ever have questions about guardianship or supported decision-making, this is another very, very valuable resource in Minnesota. And Anita Raymond, who helped me create these slides, is a tremendous resource for us, as well as her team, to talk about issues that arise related to guardianship, conservatorship, or supported decision-making. Their primary role, in addition to answering general questions about guardianship or conservatorship, is to in fact help families put into place supported decision-making plans. And so, or I should say, help groups of supporters put into place supported decision-making plans. So that is a resource available to all of us in Minnesota that's incredibly valuable. So I just don't want to fail to recognize that as we go through the content here. We've done a little bit of intro. I'm going to stop and just take a breath for a moment, and we'll say, Nikki, any questions arise yet?
I am not seeing any, but please feel free to put them in the chat or the Q&A, and I'll pass them along.
Fantastic, thank you. I'm doing this audibly to remind myself to just take a pause. I told Nikki earlier I can be kind of a freight train with this information, so I want to make sure I'm checking in with everybody. And if there are questions, yes, please feel free to use the Q&A or the chat to pose those questions, and please feel free to ask questions, because again, this is complicated stuff. It's quite layered. For those of us who have worked as attorneys in this context in any way, it takes a long time to learn how these roles interact with one another and what powers and duties and responsibilities are associated with what roles. And so if you're feeling a little confused, that's a reasonable feeling. And we're here to answer those questions and try to help orient in this very, very complicated milieu. So I have much empathy for that. I have taken many, many years of fairly focused effort to feel like I understand these tools and strategies. So it's a reasonable feeling. I am now going to move to talking a little bit about the definition of incapacity as it appears in our statute, and then we'll talk about capacity a little more generally, because I want to make sure we're sort of grounded in that. In our guardianship and conservatorship statutes, a finding of incapacity is required in order for a court to impose a guardianship or conservatorship. And so this is the language that describes incapacity or an incapacitated person. And you'll see here that it's not a tremendous stretch, lacking sufficient understanding to make it certain personal decisions, etc. The thing in the definition that I want to point out is that you'll see here that this is the case that the person is impaired to this extent, even with appropriate technological and supported decision-making assistance. So here comes supported decision-making right into our statute at the incapacity definition. this suggests that we have to try supported decision-making before we can even make a determination about whether or not a person meets this threshold. Now, this is something that's relatively new to us again. As we talk about some newness, there have been statutory developments in 2019, in fact, so many folks who work in this area are adjusting to these. But this is one of those adjustments, and the requirement for supported decision-making assistance presence in even a determination about incapacity is a tremendous benefit, because it means that we're going to look to tools that are much less restrictive of the rights of the individual potentially subject to guardianship or conservatorship before we impose those incredibly rights restricting kinds of structures. So here, even as we look at incapacity, we're going to first explore not only supported decision-making, but also technological supports, which for us at the Elder Justice Center can be also very significant. Technological tools that allow people to receive or perceive information more accurately or better are very important for us. And so those kinds of things are meaningful when we are asking questions about whether someone understands. I'm talking very abstractly, but what I'm really thinking about are, like, say, for example, like a hearing aid. This is a technological device that could very significantly impact whether or not a person is tracking in any given circumstance. So when we think about those tools, really we're talking about a whole range of technological kinds of supports. We'll explore more of that in a minute. But so I want to talk in general about capacity because I'm referencing incapacity. And I want us to understand, in fact, what is capacity before we go there. Really, and I think about capacity as an empty set. It's not a thing until we define what it is that we're asking about. So it's really a person's ability to do a thing, feel a thing, think or understand something, or a combination of those abilities. And it's not really meaningful for us to talk about capacity unless we're talking about capacity to do what specifically. And so that's a first piece that we want to define. In the case of guardianship and conservatorship, we're talking about capacity to make a personal decision in the case of guardianship, or a financial decision in the case of conservatorship. So we're thinking about those types of decisions. That's how we're narrowing or defining our questions about capacity or incapacity. And of course, in general, capacity is not black or white. If a person may become incapacitated and then regain capacity. For us at the Elder Justice Center, the best example I can think of that is the very significant imposition on capacity that a condition like delirium can represent. And that's not unusual at all for folks who are experiencing an infection, for example. So it can be a very common side effect for a person who has an infection to experience delirium. And delirium is profoundly incapacitating. It makes it very, very difficult for a person to make a confident, oriented decision when they are experiencing delirium. And yet, for many people who do have that experience, as soon as an underlying cause, in the case of my example, an infection, is resolved, so treatment with antibiotics, the delirium goes away and the person regains capacity, regains their ability to make and assert a decision. So we see this as a continuum, and a person can have capacity, lose capacity, and regain it. This is why we want to be so cautious about making declarations about incapacity, because we don't always hold that notion that a person can travel back and forth on that continuum. And so we want to make sure that if we're actually making decisions about incapacity, we're both recognizing that and then being very certain that any kind of enduring structure that we put into place actually takes into account what types of decisions we're asking about, and the possibility that a person might be able to regain their ability to assert those decisions. Of course, different degrees of capacity are also required for different kinds of purposes. And so if we specifically articulate that purpose, what are we actually asking about? Then we can proceed to achieve more accurate outcomes when we're trying to form an opinion about it. Of course, with guardianship and conservatorship, again, we're thinking about personal health decisions. With guardianship, with conservatorship, with regard to financial choices. But a person can have capacity for some of those choices and not for others. Even within the context, say, for example, of financial decisions, a person may very much have the capacity to manage their own resources on the day-to-day, but they may not have the capacity to be directing complex investment schemes or strategies. So even in the financial realm, we'll see that there are varying degrees of capacity required for various purposes. With regard to certain kinds of decision making, and this can be a source that does result in discussion about guardianship and conservatorship fairly routinely, there are different levels of capacity required to assert different kinds of legal decisions. And so to enter into a contract, for example, a person is required to demonstrate what we call in the law contractual capacity. This is an example that might come into play if a person was going to create a power of attorney document. This is another decision-making tool. And a power of attorney is a contract, and contractual capacity means that a person understands the contents of the contract. So you can see that under certain circumstances in the law, that's kind of a high bar to clear. But that's contractual capacity, and it's not required for all kinds of legal decisions. Other forms of capacity are required as well. Testamentary capacity, for example, is what's required for a person to make an assignment of their belongings after they've died. So to give a testamentary instruction to say, here's who I want to have my stuff when I'm dead, I have to demonstrate testamentary capacity. It means something slightly different than contractual capacity. And then here we have on the slide, I want to just mention that the capacity to execute a healthcare directive is differentiated here because it's one of the lower bars of capacity that I think a person needs to clear. And it's very meaningful to have a healthcare directive, particularly in connection with guardianship. And I'll talk about why that is. But the capacity to execute a healthcare directive, which is a tool that a person can use to indicate who they would like to make decisions on their behalf if they are not able to, or what medical decisions they would expect to be made on their behalf if they are not able to express themselves, what degree of intervention they'd like to have. The capacity to create a document giving those instructions is generally demonstrated by a person simply saying, I want Nikki to make my healthcare decisions for me. So that's not, I don't have to demonstrate much beyond simply intent and an understanding about what that might mean if I'm asked that question. What does it mean? Well, it means that I want Nikki to decide what kind of treatments I want, and if I can't answer those questions, I want Nikki's answers to be the controlling ones. So that's, if I can express that, then I can make a healthcare directive. It becomes important in our conversation about guardianship and conservatorship because in the realm of guardianship, guardians are often sought because a healthcare or medical decision needs to be made on behalf of a person who is not able to make that decision themselves. So that can be a source of much energy around the seeking of or petitioning for guardianship, and it's important to see that the presence of a healthcare directive can oftentimes alleviate the need or reduce the need for a guardian. So that is a very valuable tool for people to have. In addition, I'll just mention this as we're on the subject, but in Minnesota, if a person creates a healthcare directive, there is a presumption of priority, and I'll talk a little bit more about this, on behalf of the healthcare agent in a hierarchy of appointment for guardian. And that is because, again, many of the decisions that a guardian is charged with making are related to the health and safety of the person subject to guardianship. And so if that person has already decided, this is the individual I want to have making my healthcare decisions if I'm not available to make them, then they have indicated a preference for whom they would like to have in place to assert those preferences. So that's a valuable tool for our participants to have, that healthcare directive tool. This is sometimes, a healthcare directive is sometimes referred to as a durable power of attorney for healthcare. Sometimes it's called a living will too. So we can see that, but really a healthcare directive does both of those things. It nominates the proxy and it gives the instructions. So with regard to capacity, I always, when I'm working with professionals, I always say, okay, we're going to presume capacity from a starting point. We're going to presume the capacity to make these decisions. And I understand that sometimes when you get calls and you have an awareness that a person is subject to guardianship or is subject to conservatorship, that this instruction that I'm giving you to presume capacity is already going to be called into question. But that's okay. We can still presume capacity and take a look at the guardianship or conservatorship, or to whatever extent we have information available to us about it, and go from there. So we can start with capacity and say, okay, well, this person may be incapacitated based on the fact that there is a guardian in place or a conservator in place. But I like to make that initial presumption of capacity. And I just acknowledge as well, in the law, we have a lot of yes, no. We saw that even in the discussion around what levels of capacity are required to accomplish what things under the law. And that the law really doesn't have a very easy time with this idea that capacity, in fact, exists on a continuum and that a person can make some kinds of decisions and not others. And in fact, our guardianship and conservatorship statutes in Minnesota don't do a great job of accounting for that continuum, or in fact, for accounting for the fact that people can learn skills and learn strategies and abilities and ways to go through their lives that will allow them to make independent decisions. So we'll see as the statute has changed what we've tried to do to account for some of that, to try to create some opportunity for people to move out of guardianship or conservatorship if they find themselves in those structures. With regard to older adults, we often kind of start from a starting point of deterioration and decline. We think of aging in those ways. And so for that reason as well, I always try to do a bit of self-examination regarding age and aging when I think about capacity. And many of us have had personal experiences providing decisional support to someone in our lives. That person may have been an older person, they may have been a young adult. But in any case, if we've had experience with that, we might know, there are very different degrees of capacity that people might experience or express under different circumstances, but that our presumptions about capacity might be impacted by a person's age or the manner in which they present. And so I think we always benefit from a bit of self-examination in that context when we're trying to make that capacity determination if we find ourselves in that position. Another important thing that I think is valuable for us is that I'm compromising what I'm saying. I was first going to say there's no way to waste time on a capacity assessment or on a determination about whether or not somebody is understanding what I'm saying, or following my way of thinking, or comprehending the guidance or advice or support I'm offering. The more time, the better. The more time we can spend talking with somebody to come to a more complete understanding about their perception and their interpretation of what we're saying in our advocacy role, or if we're representing that person in another context. Time is on our side, or time is our friend in that regard. Again, fully recognizing that professionally, that is the opposite of that is true. Time is not always on our side, and we're having to make determinations much more quickly about whether or not a person is tracking with us or understanding the guidance that we're giving, or able to make a safe decision about their health or their resources, or et cetera. So I know that there are many strategies that folks use to make those determinations. You may use other strategies to develop confidence about whether somebody that you are supporting is understanding the guidance that you're offering, or is making decisions that are appropriate for their circumstances. But the time piece is a big piece that will help us gain that insight. So I try to make sure that if I'm scheduling meetings or time with people, I'm really giving some buffer there, so that I can make sure that I have the chance to talk with them. There are direct connections here with victim advocacy, and this may not be mysterious to you in your role as advocates in particular. You'll see this actually playing out. But autonomy is a protective factor against abuse. We know that the extent to which a person is able to make and assert their own decisions protects against harm in ways that seem sort of self-evident. I think when I start to think through that, the extent to which I'm invested in decisions about my life and safety translates to enjoyment of my life and safety. And if I have been divested of that decision-making power over my own life, I may not be as attuned to compromises to my quality of life or to my safety. That's my kind of way of thinking about this, but there have been some interesting studies that demonstrate this related to safety, in particular in an institutional context. So some interesting work on autonomy here, but we consider autonomy to be a protective factor in this case. So back to the definition from our statute. And again, here we're talking about appropriate technological and supported decision-making assistance. You'll see here that the realm of personal decisions that are contemplated here come from our guardianship statute. These are things that are concerned with medical care, nutrition, clothing, etc. So not the financial decision side here, but the guardianship side, asking for supported decision-making in this way. And here's our definition for supported decision-making: assistance from one or more individuals of a person's choosing in understanding the nature and consequences of decisions. So when I think about supported decision-making, and there have been many people who have spoken, very, very eloquently on this subject, but I do often think of the routine situations in which I myself engage supporters in my decision making. It's something I do regularly. There are all kinds of things that I am, not equipped to manage on my own. For example, taxes. I get help with my taxes every year, thank goodness. That is a whole set of financial decisions that just are existing outside of sort of the realm of my awareness. And so I engage supporters when I am coming up to tax time, and some of them are professionals and some of them are non-professionals, but these are the persons of my choosing who are helping me understand my options related to taxes. I received support. The most recent example that I shared of a sort of comprehensive supported decision-making was in our last municipal elections, which were not all that long ago, last year, receiving support in lengthy conversations with the people around me that I've chosen, whose guidance I respect and whose opinions are meaningful to me, to talk about what options we had in our decisions about city governance and all these really didn't matter. So it was really wonderful to think about kind of how are there examples in our own lives in which we seek the support of others in order to make a decision. We tend to think about these things as associated with people who are incapacitated, but in fact, supported decision-making impacts all of us in all of our lives. When we do think about it in this way, as a concept that we might invoke in the context of guardianship and conservatorship, when we speak of supported decision-making, we're talking about a specific thing or specific things that we can do to help others with decisions about health, safety, or finance. So here's our definition from the statute. Nikki, hi.
Hi. So we had a question pop in. I'll let you finish the slide if you'd like, but it's
sure. I'm happy for the question. Let's hear it.
I love this question. Someone asked, would a therapist be considered a supportive decision maker if the individual chooses them?
That's a wonderful question. I'm going to answer it from the perspective of supported decision making. If we have therapists who have licenses in the crowd who can speak to that, I'd be curious about that. Also, that may be a subject for another time too, but I think that, so I wonder if I can, I have kind of a list of, well, it's not, I'm not going to exit from the presentation mode. I have a list of kind of least restrictive alternatives or examples of supportive individuals or structures. But my answer to that question is yes. A therapist is a person who could serve as a supporter because a therapist is a person who helps provide decisional support. And really, I know that I've talked about a lot of technical language, but when we come to supported decision making, we do have a great degree of flexibility as individuals in defining who supportive persons are. Now, that's not to say that if I approach my therapist and say, I would like you to be a supporter for me in this realm of decisions, that my therapist will then be that person. They may say, no, I'm not equipped to provide provide that level of engagement, or I'm not comfortable with, that type of support. But so there are individual options there as well. But I believe a therapist could be considered a supporter by a person who is seeking to bring together a team of supporters. And this will become interesting too when we talk about the sort of statutory basis for decision making. Because I think something that's important to know about supported decision making is the value of it in many ways is the flexibility, who we can identify, the range of individuals we can identify as supporters, and our ability to seek guidance from them. Of course, the notion here is that, we're each our own individuals and we presume capacity of ourselves. So, if I want to bring around me a team of people that I'm going to ask for advice about my taxes, for example, I can do that as an individual, and I can involve those folks in conversations, and I can share information with them, and I can decide who among them get to share information about me with each other. So I have some ability to create a very flexible shape for a team. And that can be really meaningful when we're thinking about trying to create alternatives to the rights imposition of guardianship or conservatorship. It's a kind of a very I know a meandering and vague way to answer that question, but I would consider a therapist to be a person who could be a supporter, could be considered by the person at the center of a supportive team, a supporter of theirs. I'll talk about some other examples of supporters as we go through to our conversation, because I think there's lots of different ways of thinking about it, how we can do supported decision making as the activity. So in brief, when we're thinking about these kind of legal interventions of guardianship and conservatorship, here are some of the thresholds that we are going to look for in order for a court to impose these structures. And so we've seen, again, that we have to meet that definition for incapacitated person, which means, challenges in decision-making about personal matters, medical issues, safety, et cetera. And again, this reference to technological supports as well as supported decision-making. We've got to show both of those things in order to meet that bar. And so I'll talk a little bit more about what that looks like. These are these are our incapacitated person definition, and we can see that supported decision making is present here. But we also need to meet supported decision making outside of that determination. So no matter what, it's going to be required. If we don't demonstrate that supported decision making assists a person in achieving capacity in the context of their definition as an incapacitated person, we then still will face it in this other element that we need to meet in order to impose a guardianship, which is that no less restrictive alternative to guardianship or conservatorship, including less restrictive substitute or surrogate decision making, less restrictive than guardianship or conservatorship, would be appropriate. So we're talking here about less restrictive alternatives that can include supported decision making. So it's coming into our statute in multiple ways, and is a concept just in general that we want to make sure we can comfortably contend with in our work with others, because it will continue to arise, I think, for all of us in public-facing service roles. Questions about the definition. That's a little convoluted, and I'm thinking, like, I don't like that I have it on 2 slides, because then I have to go back and forth to get all the criteria. But you can see here, we've got both the supported decision-making requirement in the determination about incapacity, which is required, as well as in an identified less restrictive alternatives, or in the demonstration of an efforts towards less restrictive alternatives. We'll see that discussion about what less restrictive alternatives, including supported decision-making potentially, had been explored, is required in the petition now. And here on the same side, we'll just take a look at what is required for a conservatorship, an intervention that is intended to assist in financial management. So guardianship, personal matters, conservatorship, finance. Here we have this concern about wasted resources or danger or risk, high risk to resources, particularly on behalf of a person who needs those financial resources for their support. And then again, here we come back to less restrictive alternatives to conservatorship as well. These can be, again, both supported decision-making, in which the individual themselves is the final decision maker and they're surrounded by supporters who can help them arrive at that decision, versus what I would call a less restrictive substitute or surrogate decisional structure, such as power of attorney, in which we actually have a person who is empowered to make a decision on behalf of somebody else in a sort of limited range of financial matters. So that's a situation that's less restrictive than conservatorship, but it is not necessarily supported decision making because I have a second individual who gets to make a final decision. So let's see there's a bit of nuance there that I think I probably failed to adequately articulate earlier. But so we're seeing, again, with supported decision making, the individual around whom the supportive team coalesces is still the final decision maker, still retains the authority to assert a decision. And that can be even if the decision is in conflict with the advice of the supporters. Again, this is also because we've got a flexible, adaptable structure in supported decision making.
So, Merritt, would you mind clarifying when you're talking about the individual, the supported individual being able to make the final decision, even if it's in conflict with the supportive and decision-making individuals?
Yeah.
What's the standard for challenging that and saying, you know, they've made such horrible decisions, we need to have a guardianship or a conservatorship?
Absolutely. So we would want to take a look then at some of those questions that come back into our legal intervention, our requirements for legal intervention. I'll come back here to this guardianship requirement. The inability to meet personal needs for medical care, nutrition, clothing, especially when we can say, like, you know, even when supporters are present, even when supporters are offering kind of what we might consider to be meaningful guidance, still we find that a person continues to be in, you know, dangerous or high risk situations, and that there can be some demonstration that despite the presence of supporters, these scenarios continue to arise. You can see, Nikki, it's fairly fact specific to an individual circumstance, but there comes a point at which exactly like the presence of supporters no longer makes a difference and somebody continues to be at a particularly high risk. That's what we're hoping we can kind of move towards as we bring this concept of supported decision-making into the guardianship and conservatorship law.
We did get kind of a additional question on top of that.
Sure.
So I want to make sure that I get a chance to ask that. Kia, if you'd like to jump in and clarify what I'm about to try to paraphrase. Kia was asking about perhaps if the supported decision makers, maybe their advice is not in the best interest of the individual.
What a wonderful question. Yeah, that's absolutely true. And what happens, that's another implication there, what happens when supporters disagree? When one is giving this guidance, another giving that. So this is the situation really that mirrors the kind of situation we might find if anybody is in a situation of higher risk or is making choices that maybe don't result in high risk, but that I might not, agree with either as, as an advocate for that person or a supporter of that person. In that case, I want to go back. I want to see how you phrased. Oh, I can see. I want to see how you phrased that question so that I could make sure that I was actually answering it adequately. But if a supporter is a person who is not providing, meaningful support or is advocating for risk, and I become aware of that as another supporter, I would really use my influence in the same way that I might with a friend, and say, I don't agree with that course of action that's being recommended by this other person. The question, I think, becomes when if a person's decisional capacity is compromised in such a way that we worry they may not recognize that. And that does become a complex question for groups of supporters to understand. Okay, wait a minute, when we disagree about how to advise, in the flexibility that we have in Minnesota with regard to supported decision-making structures, individuals who bring around themselves supportive teams or the teams together can create those kinds of ground rules and kinds of structures within a supported decision-making agreement. And I'll say that in some states, supported decision-making agreements can be statutorily described and have statutory requirements that must appear. But in many states like Minnesota, there's just a tremendous amount of flexibility in the way that these types of agreements are crafted. And so when I would think about risk and harm, I would start maybe with the person at the center thinking kind of, okay, what are we wanting to be particularly vigilant about? What is that person asking specifically for support around? And then what strategies for resolving conflict might we put into place within the team first prior to invoking other tools or strategies that we might use when we're concerned that somebody is posing risk to another. Again, I know that was very theoretical and vague, but I hope that helps. It's also, it's ultimately, the role of supporter is ultimately undefined to some extent, which does give us flexibility in our response to that person. Unlike in a guardianship or conservatorship, when we're concerned about the actions of a guardian or conservator, and then we need to go back to the court, which is the supervising authority in those contexts. So we don't have a same kind of supervising authority in supported decision-making agreements beyond the authority of the agreement that we create ourselves. Maybe that organizing that thought in that way is a little bit more straightforward. Please let me know if you have follow-up questions about that or what might happen in those instances, because just as we talked about with guardianship and conservatorship, certainly we can see that in some situations that power balance between the person at the center and then the supportive team can be significant. Let's see, make sure I have on my slide. Okay, we're talking about criteria for legal intervention in conservators and the way that supported decision-making comes into these criteria, how we have to demonstrate that. I should quickly do a time check because I'm lost in this wonderful world of conversation about guardianship, conservatorship, and supported decision-making. Well, okay, I do think it's valuable to spend a little bit of time on less restrictive alternatives to guardianship. Some of my slide content for the last part of our time together today focuses on our guardianship statute and conservatorship statutes, investigating the way that the statutes are structured and what they say. And so I'll focus a little bit on some of this interpretive material, and then we'll maybe move more quickly through the statutory content. These are some of the various ways that we can explore less restrictive alternatives to guardianship and conservatorship, and some of these very much involve individuals we would identify as supporters. So cooperation with others' inputs, that's a supported decision-making structure. Cooperation with the input of others, supporter or family involvement in decisions, even if not specifically articulated or defined as a supported decision-making structure. That can be a less restrictive alternative. I talked about healthcare directives, powers of attorney to some extent can represent less restrictive alternatives to conservatorship, and we'll see that come up. Another relationship that I want to call out is a rep payee for Social Security. This is something that might not arise so often for you, but it definitely arises regularly for us and is a reasonable alternative to guardianship or conservatorship. Sometimes if a person is receiving Social Security and that may be their only source, only resource. It's really not necessary to have a full conservatorship if that person's not able to make decisions about that Social Security resource, because Social Security Administration has a structure called representative payee that allows one person to make decisions regarding Social Security income for another. The structure exists in Veterans Affairs as well, called the VA fiduciary. So for folks who are veterans, there's also this less restrictive alternative to a conservatorship. And then all kinds of, here we'll see all kinds of issues. You'll see commitment on here. That's pretty interesting. Commitment is a time-limited intervention where guardianship is not necessarily time limited. And so we can think of that in some contexts as less restrictive than guardianship because it will have a time of conclusion. So just a few of those examples. What technological tools do we have? This is significant in the conservatorship context because more and more we are able to do quite complex remote banking and have auto pay structures that can help manage finances. So again, such a valuable tool for folks as a less restrictive alternative to conservatorship. I thought I had a slide here to Kia's question. I thought I had a slide that listed, or Nikki, that might have been your question before too, that listed other individuals that we could consider supporters. But I tell you what, I'm having actually a hard time coming up with somebody who could not be one. You know, I mean, if I was going to bring a team of supporters together, you know, I can think of people in my close personal circle that I would just definitely want to have involved, whose ideas I respect or thought or way of thinking. I can think of folks who definitely, you know, will represent my personal values about healthcare. I can think of one of my healthcare providers that if I could get that person on my team, I would sure want to have them there. You know, and then you know, I talk about that like it's, you know, like it's some effortful thing. Well, you know, depending upon how I wanted to structure my team, did I want to have them engaged in my day-to-day decision making? Well, then my provider might not be interested. It might be a little bit more than they're contemplating. But would I prefer to have that person just help me with a specific narrow range of decisions? Then they might be willing to serve in that role. And for us as advocates, I think this is a thing. This is a layer of the question that I haven't touched yet. But you know, we become in people's lives a source of support. And certainly, you know, that request perhaps has already been made to you or to somebody that you know in this role, right? Could you be my supporter? I'm creating a team of supported decision making. If it hasn't happened, I expect that it will, because we are more and more emphasizing this way of decision making as alternatives to what can be an onerous, again, imposition of guardianship or conservatorship. So we're looking to supported decision making, attempting to emphasize that. And you may be asked, can you be a supporter? Now, for a lot of reasons, I think that could be complicated for an advocate to do, because we are, in fact, providing a very, very specific kind of support under specific circumstances. And when a person is looking for a supported decision-making team, they may contemplate a wider range of decisions than we might be comfortable entering into in our advocate role. So that's one limitation that I might offer if we would consider that or having to field that type of request, which again, I think if it hasn't already come, it will come because of the trust building that happens between individuals and folks who are serving as advocates on their behalf or alongside them. Some other alternatives that are less restrictive than guardianship or conservatorship here, trust, very flexible, another flexible structure that can be tailored to specific types of decisions. So a valuable tool. So in the petition, we actually have to say what less restrictive alternatives have we tried here? Why didn't they work? And so why then, therefore, do we need a guardianship or a conservatorship? And that's very helpful. That has not always been the case. And obliging us to be specific about that is meaningful. the level of specificity that is offered in petitions, as well as the level of specificity that courts require to see, varies greatly. And I think that as we continue to talk about supported decision-making and less restrictive alternatives to guardianship and conservatorship, we'll continue to see more detail, and we'll continue to see courts asking for more specific information regarding less restrictive alternatives. So we'll see, and we have to have specific findings again around those issues. So we'll start to see them having to appear more precisely in the petitions that generate them. So I want to talk a little bit about limitations on guardianship and conservatorship. We'll talk a little bit about rights, the rights of an individual under guardianship and conservatorship, powers and duties, and time frames. And I'll move a little bit more quickly here. So an individual subject to guardianship or to conservatorship does retain all of the rights that are not called out specifically in the guardianship or conservatorship order. And so this is something that I think can be challenging conceptually, partly because of the way we tend to think about incapacity. When we think about an incapacity determination, we just tend to think about it as global, or actually, I shouldn't say that. I need to use I statements. I think about it as global. I still do, and I live in this world, but I still tend to think about it as a global determination. Oh man, this person had capacity and now they're incapacitated, and that's it. But courts can be very precise about how those particular rights are restricted. Both our statute both allows for that, and the structure of many of these tools allows for great specificity about which powers are retained by the individual and which have been given to the guardian or conservator. So one of the great challenges of that is when we're working with somebody who indicates that they are subject to guardianship or subject to conservatorship, one of the first questions that I have is, to what extent is that the case? Actually, the first question I have is that truly the case? And the reason I have asked that question is particularly around the language of guardianship, because oftentimes, we use the word guardian or guardianship in a casual way, or that's an informal way. I'm not sure what word I'm looking for there, but in a non-legal way. I'm the guardian of this person in my life, and looking out for their interests. And what I find is that folks who engage us at the Elder Justice Center are often use that language. Well, I'm my mom's guardian. Well, are you a court-appointed guardian? Or are you just, you're helping out? And we often discover that that's the case, that they're using this language. Person who's engaging us may be using this language, or I have a guardian. Is it a court-appointed guardian, or is it a person who's ostensibly looking out for your interests, or helping you with something? So those are some of the first questions. Then the next question is, if it in fact is a court supervised guardianship or conservatorship in this way, then what powers have been contemplated? The most commonly imposed guardianships and conservatorships at this point are what we call plenary guardianships or conservatorships, that they involve all of the possible rights and duties available to the guardian. So removing all of the decisional rights that guardianship can remove from the person subject to guardianship, removing all decisional rights conservatorship can remove from the person subject to conservatorship. That's a plenary guardianship or conservatorship, is most common, but is not required. We can be much more specific, and I'll talk a little bit more about those powers and duties. So we have to demonstrate a necessity, and that was sort of showing what less restrictive alternatives have been tried, why don't they work, etc. So we need to show that they're meaningful. And then at that point, too, the court retains some authority. So the conservator or guardian is still required to answer to the court about the decisions that they assert on behalf of the person under guardianship. Look here, you see this legacy language. I don't know, I'm going to get that out of there. That doesn't belong there. Only the powers necessary to provide for the needs of the person subject to guardianship or conservatorship. Here are some of those powers with regard to guardianship. And you can see some issues of significance here, including place of abode, where the person resides. All of the things that are offered to them to meet their needs, what they get to keep and use and own, healthcare decisions. And again, we can say, oh, well, for some reason, I'm kind of trying, I can't think of an immediate example of this, but for some reason, the court believes that a person is not able to make safe decisions about where they live, but certainly are able to make safe decisions about what they own and what type of medical intervention they might experience. And so we will give the place of abode power to the guardian, but we are not going to give that medical decision-making power to the guardian. And that's a way that guardianship can be limited by the court. But it also has this implication for us as service providers that we have to see how the guardianship is structured in order to understand the extent to which we might be expected to interface with the guardian, or maybe even more applicably for us, in the cases that we might face, and I'm talking about us collectively today on the call, that the way that we might push back if a guardian is attempting to assert or insert themselves in a situation in which we feel it's not appropriate. And so, so that helps us, I think, to understand the limitations on a guardian's power. Again, we'll often find that those powers are extensive because the most common form of guardianship is the most comprehensive kind, but increasingly we hope to see those more limited guardianships or conservatorships. So a question to ask ourselves when we're stepping into those roles. Here are the powers. Oh, Nikki, go right ahead.
Yeah, I just want to clarify. So in my experience as an advocate, and I'm hoping others can jump in and tell me whether or not they've had similar experiences. Most of my interactions with guardianship conservatorship were under the auspices of doing a petition for an order for protection or a harassment restraining order, where I have to attach that conservator or guardianship order. But what I'm understanding from you is that the guardian or the conservator can't necessarily file that petition because the person that is under the guardianship or the person receiving conservatorship actually retains the right to decide who's in their life, unless it's stated in the order otherwise, correct?
True that, and I think you'll find that in our general plenary guardianships or conservatorships, that power will be present. And so I think that we want to allow, certainly, when we think about harassment restraining orders and orders for protection that are going to limit contact for the person subject to guardianship or conservatorship, we're going to be particularly careful because, again, it limits the person's ability to see specific individuals of their choosing. It's a place where we see a tremendous amount of conflict between persons subject to guardianship and guardians or conservators. But if a guardian, because again, this is not a power that a conservator holds, but if a guardian is going to restrict access in any way, including through the use of these types of legal tools like harassment restraining orders or orders for protection, if the guardian is going to restrict that access, they have to give an explanation for why. They have to provide notice to the person subject to guardianship. And so that conversation has to take place. That we want to see from the person subject to guardianship that they've been given information about why they are not being allowed to have contact with someone. So that's the first strategy, or the first sort of step that we have to clear if we're going to be restricting as a guardian, if the guardian is going to attempt to restrict contact with any other people. We can take a look too that that's a new in our statute as well, that requirement for notice, and that's actually helpful to us in that sort of restrictive effort that we sometimes see. In fact, Nikki, that's such a good question because that is the issue of restriction, whether related to harassment restraining orders, OFPs, or otherwise. That issue of restricted contact is a huge issue within the context of this conversation about guardianship or conservatorship. And I think something I want to point out, because if in case I breeze past it when we get to the slide, which is just this piece that a guardianship is it's not an enforcement mechanism in this way that a guardian can't force a person to do something that they refuse to do, like physically refuse to do. So, or if a person, chooses to maintain contact with someone, despite, certain hurdles or obstacles that a guardian has put into place, a person can do that. They may not be able to legally do it, but they certainly can practically do it. Contact on in using various different technology or social media or telephone or et cetera, or people can figure out how to do what they want to do. And so the functional the function of a guardianship or conservatorship is higher when the guardian and the person subject to guardianship are able to discuss and explore these things as they arise, versus have them emerge out of nowhere, out of the void. Just a reflection on that, Nikki. I know that is, again, not necessarily going to be the case in every situation, but for those instances in which you find yourself being asked by a guardian or by a guardian to restrict or to limit contact, there is a question about whether or not the guardian has adequately notified the person subject to guardianship about those restrictions. I do want to mention this. This is another new development in our law, this question about limitation of time on guardianships for individuals under the age of 30. So the court can limit a guardianship in that way. Again, the court has flexibility here, both about the delineation of specific powers that are assigned to the guardian or the conservator, but also to the time frames. And many guardianships are, which are imposed after a person is over the age of 30, are not limited in terms of time. They are, what's the word for something that is not limited in terms of time? It's not durable. It's not endless. That's not the words I'm looking for. Anyway, I'm missing words today. Thanks for bearing with me, everybody. But indefinite, there it is. Hello, an indefinite period of time for the guardianship or conservatorship. Anyway, that indefiniteness is not required. A court can say, no, this is going to be for this amount of time, and then we're going to revisit. But if a person is under the age of 30, then the guardianship has to be limited in terms of time. It can exist for no longer than 72 months. And the idea, of course, here is this is all based in what we know about the developing brain. A person is just between the ages of 20 and 30. A person is just learning how to live independently, and they will learn many skills about how to live independently in that time frame. And so we want to take a look at guardianships that are imposed upon individuals who are in that time of tremendous learning about how to adult, as we sometimes say. So in any case, if a person's under the age of 30, then that limited guardianship is what will result. It will automatically expire unless it's renewed. It can be filed again at age 29 for a more lasting arrangement if that's what's appropriate. And responses to that are often these concerns. How do we deal in particular with the costs of petitioning? Because guardianship as a court process is not free and can be costly. So there's this question about forcing families, and this is often how it arises, for a person with a long-term disability who reaches the age of majority in that context, and then is going through the decade of their 20s. Many folks who are supporters may know that person will always be in a position to receive decisional support, and that repeated costs of petitioning can be a source of stress. But the response, I think, there is that their skill building takes time, And it also takes resources, and perhaps if there's a concern about resources or costs to petitioning, there could be a redirection of those resources towards skill building or independence in ways that might make it unnecessary to re-petition for guardianship. That would be ideal. So we think about that, often thinking about just timeframes. We do have concepts in our law in Minnesota around emergency guardianship and conservatorship. Sometimes if there is a significant risk or danger to the person subject to guardianship or conservatorship, or potentially subject to those structures, an emergency guardianship or conservatorship could be imposed. I think it's important also to consider this piece of impact on the person. A hearing on a guardianship petition is laborious for the individual subject to guardianship. Much of their personal information about how they approach decisions in their lives, scenarios in which they may not have made great decisions or may in fact have made mistakes, are being aired publicly. And so the impact on a person from the petition itself and the related court proceedings are not to be underestimated. That's, leave it at that. And again, I did allude to this when we're talking about guardianship and conservatorship. We're talking about consent powers. There is not a way to force a person to physically do a thing that they don't want to do in this context. So really, we're talking about, functional relationships are necessary in order for guardianship and conservatorship to achieve the goals that it is intended to achieve. Here are some, considerations, of course, if we're actually thinking through this kind of nomination. I'm not going to spend a ton of time on this because we're not petitioning for guardianships or conservatorships, but it's just something to be aware of when a person becomes a guardian or conservator. It could potentially be a challenge to a person's role in that context if there are issues here with regard to actions in the past that might appear in a background check that of course could prevent somebody from serving in that role. And then whether or not they're meeting their reporting requirements and the notice that's required around reporting. That can be a challenge if a person is not adequately meeting that responsibility as a guardian or conservator. And then there's the priority of appointment. Again, if a person has a healthcare directive, their healthcare agent will have priority of appointment. And there are some other schemes that might generate priority of appointment, but that's my primary consideration is there a healthcare agent that has been nominated. Just briefly on court procedures, again, the petition is filed. There's an effort towards exploring these least restrictive alternatives. And generally, we would hope to see that before we see a petition get filed. Once the petition is filed, that doesn't leave a lot of time to explore meaningful, less restrictive alternatives. We're looking at who's been appointed, as well as here's where we might see either the introduction of need for a physician's statement in support of a guardianship or conservatorship. And we'll see those sometimes. We certainly hope that if there's a physician statement in support, that it's meaningful and that it's being provided by a physician that actually knows this person. And that's a reasonable challenge to these. Is this idea that the physician in fact does not have a relationship that allows them to meaningfully assess whether or not a person is able to make certain kinds of decisions. And then sometimes there are folks who are especially trained in order to make a kind of decisional assessment or to give a impression or opinion about somebody's decision-making in particular realms. So in that case, we might see specialists who don't have long-standing relationships with individuals potentially subject to guardianship or conservatorship respondents in these cases, but I'm looking for that long-standing awareness of that person's decision-making and or some special expertise that might entitle them to make an assertion about a person's decision-making without really knowing them. And this is kind of our regular procedure, and I'm happy to answer any questions that might arise about, the court process. Here, some level of complexity here in terms of ensuring that court visit is scheduled. Court visitor is a person who visits the individual, the respondent in the case of a guardianship petition, to discuss with them the meaning of the petition and their circumstances, and to make an assessment about the need for guardianship or conservatorship, and reporting that to the court. And anybody who is a respondent in Minnesota is entitled to an attorney to represent their interests in the hearing on the guardianship or conservatorship petition. And so we have a attorney panel for individuals who need a court-appointed attorney, and some of our colleagues to serve in that capacity when an individual is a respondent in a guardianship or conservatorship petition. Once the court appoints a guardian or conservator, sometimes they'll require a bond, particularly for a conservator if they're managing resources. And then the conservator guardian signs their oath and acceptance. A lot of questions arise around training available to people who are suddenly finding themselves in these roles. Sometimes those individuals are supporters or non-professional folks in the life of the person subject to guardianship or conservatorship, and there are sort of limited training materials available for individuals stepping into that role. And so a lot of people are kind of, they're coming in without a lot of resource in terms of how to do that role. So I do understand that, that there are a lot of questions often in the minds of folks who find themselves in that guardianship or conservatorship position. And then also just makes, for me, in terms of my interaction with guardians and conservators, you know, I operate with some degree of suspicion because of the power issues there, but also try to find that place of empathy because they have often been given very little information about how to serve in that role. So when we think about these specific considerations or potential challenges, you know, there are these interesting questions about, you know, does the person actually meet that statutory definition? As we've talked about it, it's, you know we need to be able to demonstrate that a person is not going to be able to use a group of supporters. So do we actually see all those requirements there? And then what can we actually say, and how have we actually demonstrated that less restrictive alternatives have been, here's this word, Anita offered this in the slide creation, and it's so right on, is have they been authentically tried? It's one thing to say that, oh no, the person had an attorney, in fact, under a financial POA, and they, you know, but they continue to, you know, be defrauded or whatever, whatever harm or risk might occur. But what I want to know is, you know, what steps did the person who served as the attorney, in fact, in that context, actually take? What actually was tried? What conversations happened? What power was exercised based on the financial POA document? Accounts moved or changed or protected in some way, or, you know, third-party notification added to the, you know, what is meaningful there. And then, of course, there's this other layer that kind of lives on top of the law, which are the ethical considerations here. Again, you know, these are going to be questions that maybe in our role as advocates we could pose if we found ourselves in a conversation with somebody who was maybe seeking this authority, or if we were talking with somebody who had a question about whether they needed someone in their life as a guardian or conservator, sort of these questions about the imposition on rights, excuse me. And again, this question about compliance power versus consent power, is the guardian actually going to be able to solve the problem that we're talking about? You know, if the relationship isn't healthy between the guardian and person subject to guardianship, that may not be the case. And that's not the only reason. It may be, in fact, the case that there's just the problem that's concerning others is simply not a problem that a guardian can solve. You think about this, trying to think of a good example of this that will be meaningful in our conversation. I mean, in some ways, it did arise in that very good question about contact. You know, if I want to be in relationship with someone and I have various means of being in contact with that person, unless a guardian is with me at all times, which is unlikely to be the case, you know, constantly present at all times and in all situations, there's no way that a person would be able to control, you know, to what extent. If I was seeking out contact with somebody, I would be able to find a way to do it. Again, if I'm living in community, and that's the idea, right, is that we got like people who are living in contexts that the guardianship or conservatorship will allow a person to remain in that type of a context. Practical issues, legal, ethical, practical. What will happen in a petition? Is it meaningful? Is if there's nobody to serve in a non-professional capacity, are there resources to support the reliance on a professional? That's not insignificant. And then very significantly for us in the guidance we're giving, could opposition to a proposed guardian or conservator result in an unfavorable outcome? This is really the situation where we want, we may be able to demonstrate that a person is incapacitated, that less restrictive alternatives are not appropriate, and we have two family members, both of whom want the decisional role. And if in many courts, if that becomes clear in the petition process, the court will appoint a third party. And so that's something to be aware of. You know, if we can't find a way to work together, then we may not be able to work together at all. And so therefore, then there might be somebody totally new. And that's another practical consideration that surely does arise for folks in that context. And then what's the plan? Again, we know these can be imposed indefinitely, but why would they be if there's any way we could work towards termination and restoration of rights? That's the objective. Guardianships can be modified, and I've been talking at length about them being indefinite, but that's not necessary. The powers can be reorganized, and the powers that are given to the guardian can be modified, and powers can be returned to the individual subject to guardianship or conservatorship. If one guardian is not proving to be appropriate or not able to meet the needs of the person subject to guardianship, then they can be replaced, and they can be replaced pretty quickly too. So that's something to be aware of as advocates. If we see a situation where a person is really, really not meeting their duties, or really in violation of their responsibilities, is perpetrating, then we can appeal for a successor guardian. We always engage the court in instances in which we have guardianship and conservatorship as quickly as possible if we become aware that harm is taking place within the context of that relationship. And then guardianships can be terminated. That's a process called restoration, and it does mean that the guardianship ends and the individual then is restored to decisional control over all of those areas that may have been given to the guardian prior. So Minnesota Adult Abuse Reporting Center, Adult Protection Reports, that is one option for problem resolution. It's not always the option that's most desirable to the person subject to guardianship, but sometimes it's an option that they recommend or desire to pursue. And so we can simply be aware of the Minnesota Adult Abuse Reporting Center as a potential avenue for us if we become aware of problems. You know, informal, again, attempts at better communication, that can be meaningful because we're thinking about potentially an ongoing relationship with the guardian. Helplines, you can call MEJC, and then I'll share the Center for Excellence in Supported Decision-Making Guardianship information line that can be helpful as well. I want to also talk about that many guardians and conservators are represented by an attorney. Not all, but many are, and sometimes those folks can be great sources of education for their own clients, and we have appreciated that in the past. Ombudsmen, and I'll talk a little bit about our ombudsman for long-term care, are great allies in this context. Mediation is available, and then going back directly to the court when we're concerned about the actions of a guardian or conservator ultimately becomes very important, because the court holds the information all together. And so when we're looking at a picture, for example, if we're asking for a successor guardian to be appointed, I would like to create a record of that need by taking issues to the court to the extent that that's the objective of the person subject to guardianship or conservatorship. Petition to terminate. So there are sources of standards and best practices in guardianship and conservatorship, and this can also really be helpful. Both Minnesota, the Minnesota Association of Guardians and Conservators is MAGIC, and the National Guardianship Association have standards of practice that invoke supported decision making, as well as make clear what approach to decision making is appropriate for guardians and conservators. All of those resources, Nikki, to your original question about OFPs and HROs, all of that guidance is going to center the available decision making of the person subject to guardianship or conservatorship. So valuable to see that guidance coming from these associations as well, reminding guardians and conservators that really, whether they have plenary powers or not, they should look to the individual first to see whether or not that person can assert a decision. Well, the last point here for folks who serve as guardians or conservators for multiple individuals, if a person is removed for cause, that may call all of the other guardianships or conservators, if a person, for example, is a professional guardian or conservator or fiduciary, all those other potential relationships into question. So that's a significant, it's significant. Minnesota has a Office of Public Guardianship in the event that a person has a developmental disability and is not able to be served by another guardian or conservator. And in this case, there are some very specific and formal procedures to go through in order to engage the public guardian. This is a more rare arrangement. And so if you do find yourself engaged with a person who has the Minnesota Public Guardian or Minnesota Public Guardian, I'll refer you to the Public Guardianship Office, as well as happily engage anytime if a person has questions about how to connect with or how to resolve issues related to public guardianship. Again, more rare and for more specific circumstances. Resources, okay. And then I know we're coming to the end of our time and I'll stop, but I can't neglect to point this out to you. I tried to make the web address on this slide for Center for Excellence much larger, and it did not, it's showing up sort of small here, but voamnwi.org/CESDM. This is the Center for Excellence in Supported Decision Making. Here you'll see some of the things that they're available to do. If you have questions about guardianship or conservatorship, they're a tremendous resource. And I can't thank them enough for their willingness to be that resource to us at Elder Justice Center when we have more complex questions about guardianship and conservatorship, as well as through this process. Excuse me, I continue to use the language of families, continuing to guide communities of supporters through a process of creating supported decision-making agreements. Office of Ombudsman for long-term care, another resource available to us for folks who are in long-term care. And then very finally, I'll put my information up on the screen, and happy to share the slides. So I will, all of these contacts and phone numbers, I don't want you to feel like you've missed them. I want to make sure that you have them. And so I'll make sure that they get to you. And with that, I have gone over my time, and I apologize. Thank you for sticking with me.
Thank you so much for this, Merritt. I do want to take a moment, give everybody a chance to kind of process this wonderful information. If there's any questions, we're going to stop recording and allow you to ask those. We'll stick around for a little bit.
Yeah.
All right.
I'm absolutely happy to to be here for as long as folks have questions. I also know it was quite a lot of information, and questions may arise later. Oh, I meant to mention this as well. If you do have questions, please don't hesitate to email, call. I could get a message through Nikki, I'm sure, and so please feel free to reach out if there are questions that have arisen that you haven't had a chance to pose.